Welcome back to This Explainer. Today, we are going to completely break down the exact constitutional blueprint of India's high courts. Look, if you've ever tried to study the Indian judiciary, you know the information can get incredibly dense incredibly fast. So we're going to fix that. We're transforming those heavy, dry syllabus notes into a highly visual, easy-to-remember framework so you can see exactly how these massive institutions are built, staffed, and run.
All right, let's just jump right in. Looking at our source material for today, these authentic, handwritten prelims POV notes, you can tell we are tackling some serious exam-level facts. There is absolutely no fluff here, just the core constitutional mechanics that govern the higher judiciary at the state level.
So here's our game plan. We're going to build our understanding systematically through 5 steps: mapping the high courts, appointing the judges, transfers and temporary roles, supervisory powers, and finally, what it actually means to be a court of record. Let's get to it.
Section 1. Mapping the high courts. Let's figure out where they actually sit on the map. Okay, so our constitutional baseline is Article 214, which basically says one high court for every single state. Simple enough, right? But as we all know, India's geography and administration are massively complex. That's where Article 231 steps in. It's a crucial exception that literally authorizes Parliament to set up a shared, common high court for multiple states or union territories. And you can actually see this exception playing out in the real world. Take the Bombay High Court. It doesn't just cover Maharashtra, its umbrella extends to Goa, Daman, Diu, and Dadra and Nagar Haveli. Or get this, the Kolkata High Court's reach stretches all the way across the ocean to the Andaman and Nicobar Islands. It's a really smart, fascinating look at how the judicial system groups states and union territories together for maximum efficiency. But hey, there's always an exception to the exception, right? While most union territories just kind of piggyback on neighboring states, keep these two in mind: Delhi and Jammu and Kashmir and Ladakh. They are the only union territories that boast their very own dedicated high courts.
All right, moving on to Section 2, appointing the judges. Let's see how we actually build this bench.
Now, technically, a high court judge is officially appointed by the president. But let's be real for a second, the actual power lies right here with the collegium. It's a very specific mix of national and local judicial leadership: the Chief Justice of India, the 2 senior-most Supreme Court judges, and the local Chief Justice. They are the ones actually pulling the strings and recommending the names. So what does it take to make the cut? Well, assuming you are an Indian citizen, it boils down to a strict either-or pathway. You either need to have spent 10 years holding a judicial office, or you need to have spent 10 consecutive years practicing as an advocate in a high court. No shortcuts. It ensures that whoever puts on that robe has at least a decade of serious, practical legal chops. Lock this number into your brain right now. 62. 62 years is the exact retirement age for a permanent high court judge. It's an age designed to strike a balance, keeping that deep, hard-earned experience on the bench while still cycling in fresh judicial leadership. Once they hit 62, that's it. And the system has some absolutely fascinating rules for what happens when they do hit 62. First off, just for context, if they ever need to be removed before then, it is just as rigorous as removing a Supreme Court judge. Their salaries? Charged straight to the state's consolidated fund so they remain entirely financially independent. But here is the kicker for their post-retirement life. A retired permanent high court judge is legally barred from practicing law in front of any court or authority in India. The only exceptions, the Supreme Court and any other high courts where they weren't a permanent judge. It's basically a giant firewall to prevent any conflicts of interest in the lower courts they used to rule over.
Okay, Section 3, transfers and temporary roles. What happens when we need to shift the bench around?
Under Article 222, the president can transfer a judge between high courts, but again, only if the CJI recommends it. Now, this is wild. In the first judge's transfer case, the Supreme Court outright declared that a judge can be transferred even if they don't want to go. And look at how the system actively fights local bias. By convention, at least a third of a high court's judges should be from outside that specific state, and the Chief Justice is almost always an outsider. It's a completely deliberate design choice to keep things perfectly neutral. But what about daily court reality? Case backlogs, sick days. The Constitution actually gives us 2 distinct temporary fixes. Under Article 224(1), if a court is just drowning in a backlog of cases, arrears of work, the president can bring in an additional judge for up to 2 years to clear the air.
On the flip side, under Article 224(2), if a permanent judge is out sick or just absent, an acting judge steps in to keep the lights on until they return. And yes, absolutely, both of these fill-ins have to be fully qualified to be a high court judge. Moving right along to Section 4, Supervisory Powers. Let's talk about top-down oversight and control.
These three articles right here, they are the absolute backbone of a high court's muscle over its state. Article 227 gives them superintendents, which is essentially ultimate oversight over all courts and tribunals in their territory. Then you have Article 228, which is super interesting. If a lower court is fumbling with a heavy constitutional question, the high court can literally yank that case away and take it over. And Article 235, that gives them total administrative control over the lower courts. Postings, promotions, even approving vacation time. They are, without a shadow of a doubt, the bosses of the state's legal system.
And that boss-level authority trickles right down into the hiring process. The high court's fingerprints are literally all over the lower courts. Whether the state governor is appointing or promoting a district judge under Article 233, or filling out the broader judicial service under Article 234, the Constitution explicitly says the high court has to be consulted or provide a recommendation. They are basically guarding the gates, ensuring strict quality control for the entire judicial pipeline within the state.
Finally, we arrive at Section 5, the Court of Record. This is the ultimate judicial status symbol. To earn this title, a court has to pass a very strict two-part test. First, its judgments have to carry evidentiary weight across the entirety of India, meaning they set documented national legal precedent. Second, and this is the intimidating part, it has the sheer power to punish an individual or an organization for contempt of court. If a court doesn't have both that national evidentiary weight and the teeth to actually punish people, it simply cannot be called a court of record. And this creates a really fascinating parity at the top tiers of our justice system. The Constitution specifically hands this formidable dual power to both the highest court in the country and the state high courts. Under Article 129, the Supreme Court gets it. But right there under Article 215, the high courts are officially declared courts of record too. Now, if we look back at our notes for a second, there's a really specific historical nugget about this contempt power that often pops up in exams, and it's something you absolutely need to remember. See, the Constitution granted the power of contempt, sure, but Parliament had to actually formalize the rules around it. They did that through the Contempt of Court Act in 1971. But the trivia you need here is that this 1971 act was actually the direct result of a report filed by the H.N. Sanyal Committee way back in 1963. It just goes to show how these committee recommendations eventually turn into the hard laws that govern our biggest institutions.
So we've gone through the complete architectural blueprint in this explainer today, from how they map across states and union territories to the strict 10-year experience rule, right down to their sweeping supervisory powers and status as courts of record. But having seen all of that, it really leaves us with a compelling question, doesn't it? When an institution holds the pen to constitutional interpretation, completely micromanages the lower courts, and has the unilateral power to punish anyone for contempt, where do the limits of a high court's power truly end? It's definitely something to chew on the next time you see a headline about a major high court ruling. Keep this framework in your back pocket, and the whole complex world of the Indian judiciary is going to make a lot more sense. Thanks for joining me.